Good evening, everyone. I am absolutely delighted to welcome you all today to the Reader's Lecture. Tonight's lecture, entitled The Future of AI in the Justice System, a Principled and Practical Approach, a topic which sits at the intersection of law, ethics, technology, and one which will shape the future of how justice is delivered. To provide us with his insight into this important topic, we're honoured to have with us the Right Honourable Sir Robert Buckland, KC, MP, Master of the Bench, a most distinguished legal mind and public servant. I have just been informed that this is the second Reader's Lecture that Robert has kindly delivered. The first was before his time in government, some 8 years ago. During. I apologise. Of course, whilst in government, Sir Robert served as Lord Chancellor and Secretary of State for Justice and subsequently Secretary of State for Wales, having originally joined as the Solicitor General. He has been a Member of Parliament for South Swindon since 2010, and before entering Parliament, he was a practising barrister, later appointed King's Counsel, and was also appointed as a Crown Court Recorder. More recently, and of most relevance for this evening, Sir Robert has been a Senior Fellow at the Mossavar Rahman Centre for Business and Government at the Harvard Kennedy School, where he pursued a project on AI, digital courts, and their impact on international standards of justice and the rule of law. He finished that post at the end of last year and has now come back to these shores and joined LSE as a visiting professor, where he is continuing his academic pursuit in relation to these areas. Throughout his career, Sir Robert has been a forward-thinking advocate for justice reform, committed to making the legal system more accessible, fair, and effective. As we all look ahead to how AI may reshape legal processes, access to justice, and even judicial decision-making, there are few people better placed to guide us through both the possibilities and the challenges. So please join me in giving a very warm welcome to Robert.
Thank you very much. Thank you. Thank you very much indeed, Master Reader and Master Treasurer, ladies and gentlemen. It really is a pleasure. Fellow benchers, it's a real pleasure for me to deliver, as you've said, the second of my occasional series of lectures, this time on the topic of AI. Now, I do hope you're not going to have to suppress a collective groan about the topic, because the two vowels, A and I, have become, in an alarmingly short span, one of the main preoccupations of commentators, writers and thinkers across the world. On an almost hourly basis, we seem to be bombarded with more news about the latest developments in machine learning, quantum computing and agentic artificial intelligence, that it is very tempting to let things just wash over our heads and plod along as we've always done, hoping for the best. I don't think that such an approach will do. As lawyers, judges and administrators of justice, trained to spring into action only when instructed or when asked to decide on issues in a case, we are in danger of taking a passive role, assuming that we will only be asked to address AI issues reactively, as and when the administration of justice processes themselves deploy the emerging technology. The reality is that the world around us is already full of AI. It's being used by governments, business, and indeed all of us every day, very often without us even realising it. An increasing amount of material that we consider as lawyers is AI generated in whole or in part. Some of it will be misinformation, disinformation, or deepfake. How well equipped are we really to deal with these developments? And putting it bluntly, do we lawyers know what we want, what we need, and how we would like to work with AI? Now, these past few years have been rather like in the case of the esteemed hobbit with whom I share a birthday, Bilbo Baggins, an unexpected journey for me. But in the time since I left Cabinet, I've found myself embarking on a path that has taken me across the Atlantic to Harvard, across the United States, meeting legal practitioners, academics at Stanford and other places, tech bros and talented postgrads with whom I've had the great pleasure of working, and now back again, this time to the law school at LSE, where I am in the very early days of my term as a visiting professor in practice. I've also been working with my colleagues at Payne, Hicks Beach as we develop our own AI policies and ethical standards for use in our work. And down at DAC Beechcroft, I've been seeing how the insurance industry, many of whom are clients of that firm, are already using AI to help assess applications and claims. And I've benefited from the wisdom of senior academics at the Harvard Kennedy School and learned to, if not love, then at least respect economists. At Harvard Law School, I enjoyed discussing and debating the ethics of AI with, amongst others, Professor Cass Sunstein, he of nudge theory fame, whose speaking style is, if you haven't seen it, most engaging and somewhat unusual. But I'm not going to copy him tonight by plunging directly into the audience, which, given the layout of this otherwise excellent auditorium, would be a rather eccentric and maybe life-threatening thing to do. Richard Susskind, who many of you will know, rightly characterises the AI revolution as a transformational process in human evolution, not merely a bolt-on or to our traditional work and life patterns. AI is changing the very notion of work itself, making tasks that once seemed impossible now within easy reach, or making human input into work largely or even entirely unnecessary. To those who say, what will become of us? My answer is simple. It is still up to humans and the choices that they will make. Now, as AI research and development speeds up, and the race between, in particular, the USA and China intensifies, we must ask ourselves whether we are making enough room for sensible choices or whether we are allowing too much risk to develop. Now, knowing human nature as I do, I'm inclined towards the latter, but firmly believe that we can manage this risk. Today, I want to discuss the themes I've been pursuing in achieving a greater understanding of the impact of these changes on our justice systems, and to propose a balanced path forward rooted in the values of fairness, transparency, humility, and the dignity of being human. As this is such a fast-moving tableau, there is, I have to accept, a risk of becoming a latter-day Dr. Casaubon, whose academic research in George Eliot's Middlemarch proved arid and obsolescent, as he was overtaken by intellectual developments elsewhere that were not revealed to him until it was far too late. That is why focusing on current technology and coming to confident conclusions based, for example, on the fact that many current large language models regularly hallucinate is unwise. In my first Harvard paper, AI Judges and Judgments Setting the Scene, which was published in late 23, I decided to focus not on the technology itself, but about the very essence of justice, namely the question of judgment itself. Precisely what is it that lies at the heart of justice and judgment? And what is it about that human element that makes us have trust and confidence in our system? If we are aligning machine systems with human values, then it is best that we are clear about what they are in the first place. Now, AI in its most basic form refers to machine systems capable of performing tasks that once required human intelligence, such as decision-making, pattern recognition, and predictive analytics. Now, in the realm of justice, AI's applications currently range from facial recognition devices increasingly being deployed by the police, work on improving risk assessment tools used in sentencing and parole cases, right through to e-discovery and litigation and the automation of administrative tasks within Her Majesty's Courts and Tribunal Service. And more widely, the use of AI to determine minor consumer disputes, such as via PayPal for items bought online, is something that is readily accepted by millions of people. And certain state jurisdictions, such as China, have been progressively using machines to actually determine civil and consumer cases, and have deployed machine learning to audit and vet human decisions in a drive to create greater legal certainty and consistency. Now, AI offers the potential to enhance efficiency, reduce backlogs, and even correct certain human biases. But these technologies do not exist in a vacuum. They are created, trained, and deployed by people, and as such, they inherit our values, our assumptions, and yes, our failings. When data sets are constructed with ethics in mind, we have less to fear, but all too often they are not. In the case of China, data that does not advance the objectives of the Communist Party or socialist principles must not be used in the deployment of systems. Now, that's deeply troubling for those of us who take issue with the Chinese system. But the dangers of using fully open sourced and often opaque data sets in the field of justice are equally clear and should be very clear to us. Because not only is it a case of rubbish in, rubbish out, with which I know many of you will be familiar, but also issues with data protection, privacy, and yes, legal privilege too. Now, we're seeing technology that can process vast amounts of data, identify patterns, and even predict outcomes with remarkable speed. And we know that in our system, that could mean faster case resolution, reduced backlogs, and improved access to justice. AI has the potential to enhance fairness, at least in theory, by removing some of those inconsistencies and biases that human judges might bring to the bench. But we must tread carefully. Judgment in its truest sense is not just about applying rules to facts. It's about understanding context, exercising moral reasoning, and sometimes showing empathy. In the paper, I distinguish between determinative judgment, where rules are clear, and reflective judgment, which requires deeper contemplation, the sort of judgment that judges have to deploy in assessing the credibility of a witness, for example. Now, AI may be able to handle determinative judgment quite well, but I think it still struggles profoundly with reflective judgment. And I'll go back to the wisdom of King Solomon, because he didn't just apply the law, he understood human emotion. Solomon rightly decided that only the true mother would consent to giving her child away. And that was an assessment of credibility based upon a shared understanding of basic human emotions. And will we ever have full confidence in a machine reflecting emotion as opposed to ourselves? Now, bias, as I've mentioned, is another critical concern. And the systems are only as good as the data they're trained on. And if that data reflects historical prejudice, the algorithm will replicate and even amplify those biases. We've seen this in systems like the Compass system in the US, which has been accused of racial bias in sentencing recommendations. Now, in the paper, I identified 4 sources of bias in AI. The algorithmic bias from flawed or prejudiced data, a coding bias where laws are misinterpreted or oversimplified, a misuse where systems are deployed for political or commercial ends, and then a human-AI interaction bias where judges either over-rely on or reject AI input without proper scrutiny. Transparency is therefore vital. Many of these systems are proprietary, meaning that their inner workings are hidden from us. This undermines due process. It will erode public trust. So we need explainable AI systems that can justify their decisions in terms that we humans can understand. And then there's the threat of deepfakes. These technologies can already fabricate convincing audio and video evidence, casting doubt on the authenticity of real evidence. And this leads to what many scholars call the liar's dividend, where even genuine evidence is dismissed as fake. We've already seen cases in the US and the UK where deepfakes have disrupted legal proceedings. Now, I concluded that first paper by stating that the starting principle should be that AI should assist, not replace human judges. We need robust frameworks to ensure transparency, accountability, and fairness, and we must prepare our legal systems to confront emerging threats like deepfakes head on. That was the scene setter, but in my second Harvard paper, which is the actual title of this lecture, I sought to come up with some potential solutions that will be a framework for the use of AI in our justice systems. Now, a growing and real question for us now is, will people still want to use conventional court litigation systems if they can access private dispute resolution processes that are cheap and fast? Does increasing familiarity with AI mean that more and more people will readily consent to automated decision-making in justice? I think that the answer is a resounding yes. But that the consequences for the existing system and our rule of law do not have to be a zero-sum game. Instead, state systems of justice can, at their heart, enshrine principles of fairness, human rights and independence of decision-making that will be the kite mark or the gold standard of a justice system that has true integrity. This will continue to be of particular importance when it comes to crime and punishment, family arrangements for children, and reputation-affecting disputes. But here in England and Wales, reaching that gold standard in some respects is frankly proving difficult. The Crown Court backlog has almost surpassed 80,000 cases. Victims, witnesses and defendants are waiting years for resolution. The justice system is under strain, and traditional methods are no longer sufficient. In my submission to the Leveson Review of Criminal Justice, I've strongly advocated the use of agentic AI at the earliest opportunity, with the automation of routine administrative tasks and assistance in evidence reviews that can ease the burdens for hard-pressed court clerks and judges. I think that agentic AI can help to create a culture of compliance with court orders, but efficiency, of course, must never come at the expense of fairness. We know that the digital age has transformed the nature of evidential materials, with investigations now involving vast amounts of digital data, be it texts, emails, images and videos. Manual reviews are slow, they're costly. AI can help, but its deployment must be carefully governed. And we've got to distinguish between mere assistive technologies, which support human decision-making, and automated adjudication, which of course can replace it. Now, the former is already here. The latter, I believe, demands rigorous ethical scrutiny. But that does not mean that we should balk at its introduction into the system and at the earliest opportunity. In 2023, helpful guidance was issued urging judges in England and Wales to understand AI tools, to avoid entering confidential data into public systems, and to remain vigilant about bias and hallucinations. That was by the judiciary. The Law Society's guidance of the following year outlines the clear risks to intellectual property, data protection, cybersecurity and bias raised by AI, and provides a helpful checklist for its ethical use. And we know of tools like Harvey, Kira, Spellbook, which are all being developed and are already used for legal tasks. And yet adoption remains cautious, of course, due to concerns about reliability and hallucinations. And for those who are looking to governments for guidance, national and international regulation is fragmented at best, which means that moves to improve governance will have to come from the legal sector itself. Now, here in England and Wales, the Ministry of Justice has published its action plan on AI just over 2 months ago, and a chief AI officer, who I had the pleasure of meeting this very day, and Justice AI unit have now been created, and there is a cross-departmental steering group. And already we're seeing initiatives developing. For example, as part of the Digital Justice System Initiative, the department is developing an AI chatbot which will support users in helping to resolve child arrangement disputes. And responses from that chatbot will provide guidance on alternative routes to dispute resolution, which could support a reduction in unnecessary court applications. And the content that chatbot will be using is gov.uk content and uses AI persona scalable testing capabilities as well. So already the ethical dimension is clear. And the MOJ has said that it is also scanning potential for a single secure identity for each person who interacts with the justice system, which will provide a more joined-up approach of individuals across our services and to enable more accurate, timely and personalised support. But it was in the underlying principles of the action plan that I gained most encouragement. First of all, that AI in justice must work within the law. It must protect individual rights and it must maintain public trust. And that, say the MOJ, will require rigorous testing, clear accountability and careful oversight, especially where decisions affect liberty, safety or individual rights. And secondly, they say that AI should support, not substitute, human judgment. I think they've been reading my first paper. Because the independence of judges, prosecutors and oversight bodies will and must be preserved. And that thirdly, they want to design AI tools around the needs of users, that is victims, offenders, staff, judges and citizens. And finally, no duplication. Where there is a common solution that can be used across the system, avoid each arm of government building its own technology, which is so wasteful and duplicative. Now, I think these statements are a welcome sign that maybe, just maybe, the mistakes of the past can be avoided, because the deployment of older technology in parts of our justice system gives us plenty of warning as to the dangers inherent in a devolve and forget approach. Take the digital single justice procedure, introduced for minor criminal cases some years ago, which has definitely improved efficiency, but has also raised concerns about fairness, especially for vulnerable defendants. This is a system that has retained human oversight until now, but even then, injustices have arisen, with innocent people being wholly unaware of a conviction or written mitigation submissions just being ignored. And then we have the Post Office Horizon scandal. Although that relates to what is now very old IT, it revealed the dangers of opaque systems and the lack of the ability to conduct scrutiny or to challenge the veracity of the flawed data that, compounded by misconduct, ended up in hundreds of wrongful convictions and monstrous injustice. Now, these examples remind us of a simple truth. Automation without oversight can lead to injustice. So what then could be guiding principles for the use of AI systems in the administration of justice? Well, I set out 6 rules in my paper. Number 1, what I call algorithmic humility. AI must recognise its limitations, and it must defer to human judgment in complex or sensitive cases. This principle stipulates that any AI system deployed in a judicial context must be programmed with an acute awareness of its own limitations. The system should be capable of recognising when it is operating at the edges of its training data or encountering scenarios that fall outside the realm of competence. So, for example, if an AI system processing a routine traffic offence detects language in the defendant's statement suggesting mental health concerns or unusual circumstances, it should immediately flag the case for human review. This self-awareness is not just a safeguard against erroneous judgments, but a fundamental ethical requirement for any AI system that will be entrusted with matters of justice. So incorporating that first principle ensures that AI will complement rather than compromise the integrity of judicial processes. Because context is crucial in judicial matters, as it allows for a deeper understanding of the circumstances surrounding each case, ensuring that justice is administered fairly and compassionately. In LLMs and generative AI, context is likewise equally important, as it enables those systems to generate more accurate, more relevant and more coherent responses by understanding the nuances and subtleties of the input they receive. So then the second rule, that's the principle of opt-in consent or informed choice. In the initial stages of AI integration, participation in automated judicial processes should be on a strictly voluntary basis. Defendants should be given a clear and informed choice between traditional human-led proceedings and AI-assisted adjudication, including the benefits and limitations of each. And I think that this opt-in approach will serve several purposes. Firstly, it respects individual autonomy, allowing those who are comfortable with AI systems to benefit from potentially faster processing times, whilst ensuring that those who prefer human adjudication are not forced into an automated system against their will. Secondly, it provides an opportunity for data collection and system refinement. By comparing outcomes between AI process and human process cases, we can continually improve the accuracy and fairness of the AI systems themselves. But that process must be carefully managed to avoid creating a two-tiered justice system. Clear information must be provided about the nature of the system being used, its decision-making process, and the rights of appeal. For example, a defendant opting for an AI adjudication of a parking fine should be informed, whilst the process might be quicker, they retain the right to appeal the decision to a human judge if they are dissatisfied with the outcome. I think this sort of transparency is vital in maintaining public trust in the justice system. Now, the third rule in the framework is the principle of contextual sensitivity. So AI systems must be capable of recognising and flagging cases where there are broader societal or systemic issues, so much broader than in individual cases as is in the first principle. For example, if an AI system is processing traffic offences and notices a statistically significant increase in speeding tickets issued at a particular location, it should not simply process those cases in isolation. Instead, it should flag the pattern for human investigation, as it may indicate issues with road design, with signage or faulty speed cameras. This ability to identify potentially systemic issues is crucial in ensuring that AI systems do not inadvertently perpetuate or exacerbate existing inequalities or flaws in our system. And of course, it extends far beyond traffic offences. For example, in the health and social care sector, an AI system might detect a rise in certain medical conditions within a specified demographic. Rather than merely diagnosing and treating these cases individually, the system should flag this trend for further investigation in order to determine whether there are underlying environmental, social or economic factors that are contributing to the increase, and that could lead to better public health interventions and policies. Consider the case of an area where there are a disproportionate number of parking fines that are being contested. An AI system processing these cases might inadvertently miss the broader context. But by flagging the pattern, the AI enables human authorities to investigate and address the root cause, potentially preventing unnecessary penalisation and fostering a fairer application of the law. And I think that would be a distinct improvement on the current situation, which largely depends on the anecdotal experience of individual judges and courts, and is nowhere near as comprehensive or systematic as an AI system of this nature. I think these systems could also track the outcomes of contested fines to identify any biases in the adjudication process. So, for example, if a particular demographic is more successful in contesting fines, this could indicate potential disparities in how they're issued and contested. That will help ensure, I believe, that the enforcement of particular rules and regulations is equitable and just. In essence, the AI's ability to contextualise and analyse data from multiple angles ensures that it not only addresses immediate issues, but also contributes to long-term improvements in policy and enforcement. The fourth rule is one of continuous human oversight. Now, whilst AI systems may be entrusted with certain decision-making processes, there must always be a clear chain of human responsibility and the possibility of human intervention. And this rule would mandate regular audits of AI decisions, random sampling of cases for human review, and clear processes for appealing AI decisions to human judges. So, for example, in a system processing minor civil claims, a certain percentage of those cases should be randomly selected for human review, regardless of whether the parties involved have asked for an appeal. This ongoing oversight serves to maintain the integrity of the system and produces a mechanism for identifying and correcting any systemic biases or errors that may emerge. The fifth principle is one of ethical transparency. Any AI system that is deployed in justice must be open to scrutiny, with its decision-making processes explicable in clear, non-technical language. This is crucial not only for maintaining public trust, but also for ensuring that defendants can effectively challenge decisions if necessary. So, for example, if an AI system recommends a particular sentence in a minor criminal case, it should be able to provide a clear explanation of the factors that it considered and how they influenced its recommendation. And this explanation should be comprehensible to the defendant, to their legal representatives if appropriate, and the public. And additionally, ethical transparency entails regular audits and assessments of AI systems to ensure that they remain aligned with those principles. And then the final rule in that framework is the principle of adaptive learning. Now, whilst AI systems must operate within strictly defined parameters, they should also have the capacity to learn and improve over time based on feedback from human oversight. But we need to manage that capability carefully to prevent the emergence of unintended biases or to drift from established legal principles. And any significant changes to AI's decision-making processes should be subject to rigorous testing and approval by a panel of legal experts before implementation. So those 6 rules, I think, give us the first robust framework for assessing the suitability of AI integration into our system. So how then to actually deploy it in the system itself? Now, I think that we should be developing a tiered framework approach here. 4 tiers, I suggest. First of all, one of human-only adjudication that would be reserved for complex or precedent-setting cases, such as serious crimes, constitutional challenges, matters that involve serious issues with the liberty of the individual, life-changing cases that are made in the family courts, and that type of gravity. The second tier would be AI-assisted human adjudication, supporting perhaps cases of a less significant importance by aiding research and analysis with humans making final decisions. I think that the question of bias detection or policy violation is one that AI can help with, but it should be up to the judges, the human judges, to assess evidence and witness credibility. Then the third tier, which I describe as human overseen AI adjudication, allows AI a much greater role in minor matters like traffic or small claims, always with human oversight for unexpected complexities. And then finally, fully automated processing without a human to handle routine, uncontested cases, boosting efficiency. But even here, safeguards ensure that appeal rights and regular audits maintain fairness. And if the AI detects a sensitive issue, it should then be able to escalate it up to the next tier or even further up in order to make sure that there's human oversight. And we need, in order for that to be policed, broad stakeholder scrutiny by legal experts, by ethicists and by technologists, all working together as a joint board to ensure that justice remains accountable and trustworthy. Now, integrating AI into the system offers benefits, but it also presents challenges. So ensuring transparency and accountability in AI-driven legal decisions is crucial, but too much disclosure has the danger of allowing individuals to potentially manipulate outcomes. So if sentencing algorithms, for example, became fully transparent, you might start to see the exploitation of decision rules by unscrupulous representatives, potentially influencing trial outcomes, similar to the sort of strategies we see when people want to optimize whether they appear on a search engine. This raises questions of legislative intent and fairness. For example, if an AI model gives weight to community involvement and employment in a sentencing exercise, counsel might advise clients to highlight these attributes, which could affect sentencing impartiality. Now, we've seen this in financial services, where explainable AI credit scoring can lead, frankly, to gaming of the system. Ethical concerns about AI-assisted judicial processes highlight the need, therefore, for robust oversight. And additionally, greater AI transparency of algorithms in sentencing could reward coached displays of remorse or rehabilitation plans over genuine behaviour, possibly disadvantaging those with different cultural or personal expression styles. So I propose a system of calibrated transparency, which will offer varied levels of explanation, detailed breakdowns of the algorithmic process for judges and legal professionals, but more general explanations for defendants and the public, all published in accordance with the vital principle of open justice. And I think regular updates to the AI parameters will help to prevent gaming, just like the changes we see to algorithms on social platforms. Because monitoring behaviour patterns over time can distinguish genuine behaviour changes from last-minute attempts to influence AI. And human judges should provide reasoning, especially when diverging from AI recommendations, maintaining their vital role in the process. And training programs for legal professionals should be stressing ethical AI interaction rather than encouraging a cynical gaming of the system. Now, I think that approach will balance explainability and the robustness of those systems. Now, ongoing audits and adaptive measures are vital, as I've said, as new forms of gaming or imbalances emerge, but always accounting for the rights of defendants in particular and those parties in cases, so that we do not see legitimate defence strategies from being penalised. I think that these techniques can clarify AI decision-making by showing the importance of certain factors and using standardised explanation formats. For example, explaining how a criminal sentence was reached by reference to the relevant guideline and then the factors relevant to the particular case would help specify the hierarchy of differing factors, the quantitative influences that apply, the case comparisons made, and some outlier factors as well, which again all support that need for transparency, and the need to avoid gaming. Now, increased explainability might lead, as I've said, to even more sophisticated gaming and an undue deference to AI by judges. So to mitigate that, I believe that we should firmly maintain the principle that AI must remain advisory, with a human rationale required when there is a divergence. Now, in my paper, I dealt with the issue of the compilation of training data for use by the system. Now, data compliers must, I believe, work closely with developers to ensure that context and nuance are reflected in AI algorithms, and the judiciary's involvement in this will enhance credibility and legal compliance. But there may be technical limitations and, yes, historical biases. Now, I think interdisciplinary commissions between lawyers and technologists can counteract this, and that will require proper resource. Now, public-private partnerships might be a way forward, because that will bring in innovation and a greater openness in many ways. But again, the management of conflicts of interest and the need for transparency have to be very carefully managed. This is justice, after all. We've got to get it right. But a quasi-open source approach, a semi-open source approach, I think will allow key stakeholders access to the models and data for review without the need for full public release, which I think balances the concerns that exist about transparency and those proprietary issues. Because third-party validation and continuous monitoring will maintain quality and relevance, but whilst robust testing will ensure that models continue to adapt to evolving legal needs. Now, there's lots of, I think, proper reference to the creation of synthetic data, but an over-reliance on that could degrade the quality of the models, which requires, again, the need for, yes, ongoing human oversight and fresh, high-quality data. And here's another set of protocols that I would suggest. 4 layers for integrating AI into the justice system. First of all, data scrutiny. Let's thoroughly analyse the training data used for these models. We should be considering not only demographics, but historic and societal contexts as well, and collaborate with social scientists and legal historians in order to avoid the perpetuation of outdated biases. And I think that, frankly, the setting up of a data ethics board would help to oversee data collection, ensure diverse representation, and address gaps and quality concerns. And the second principle, model transparency. Let's have legal AI explainers in order to make these decision processes clear. They would translate AI reasoning into legally relevant explanations and help maintain that key judicial oversight. It will require interdisciplinary expertise. But again, that balance of openness with security against manipulation will best be preserved by that collaboration. And then continuous monitoring again, looking at real-time bias detection using advanced neural networks that can check AI outcomes for emerging biases. So all these adjustments, I believe, can help to not only support oversight, but the emergence of new bias. And then the societal impact assessment principle, which I think would need the setting up of AI justice impact units to regularly review how the use of these technologies impacts different communities. And these units would be able to combine statistical analysis and community engagement to identify disparities and to recommend systemic changes beyond mere technical fix. Now, I'd like to see the AI Justice Unit take up all these suggestions. And I have to tell you that I've given a copy of my lecture to the new head of that unit today. So let's see whether we will see at least some of these ideas put into practice. Now, before I finish, I just want to bring us back to some of the current challenges. We've got the dangers of synthetic media and deepfake. We've got these realistic fake images around us all the time. They pose real risks to legal proceedings. They make the authentication of evidence difficult. They can lead to potentially unfair trials or reliance on what should be wholly inadmissible evidence. Now, high-profile cases both here and abroad have already shown how dangerous this is. And I believe that existing evidentiary procedures are just inadequate for dealing with deepfake. Proposed solutions include investing in self-authenticating technologies to detect deepfakes, which I think companies like Adobe and others are already doing. But we need, I think, as well to recognise that there are going to be times when it's going to have to be judges, rather than just leaving it to juries in criminal cases, to take responsibility for evidence verification. But these are costly, and we are always chasing the tail of deepfake creation. And that's why I believe that some law reform is needed to ensure that we criminalise the use of harmful synthetic content in courtrooms. I think we'll have to update the law of perjury, for example, and some regulatory change to ensure that lawyers verify the authenticity of evidence before relying on it. I can also see a real utility in using blockchain technology. Yes, it's not all about cryptocurrency, blockchain technology to maintain a secure chain of custody for digital evidence. Now, another challenge posed by AI is future reliance on the court system itself. As AI becomes widespread in daily life, public trust and reliance grow, as I said at the top of my lecture. But this might lead to private dispute resolution via entirely automated systems, making state courts, frankly, less relevant, less central for private cases. Now, this shift should raise concerns in all our minds about how we evolve the law itself through accessible public judgments. Will parallel dispute resolution procedures make state court processes in areas other than public criminal prosecutions increasingly marginalised? And the government use of automated decision-making, like benefits distribution or issuing documents, can affect accountability. Judicial review relies on the duty of candour that governments have to display in the disclosure of material upon which they make their decisions, so that we can challenge them if we think they're unreasonable or disproportionate. Now, without explicable AI, how do you do that? And enforcement of judgments, which is increasingly seen as suitable for automation, is, again, potentially a bit of a minefield. Whilst I agree and endorse the Civil Justice Council's recent report, which recommends a digital court portal for tracking finances and streamlining civil judgment and enforcement, we've got to have judicial oversight to prevent abuse. And reliable databases and the careful integration of AI are essential if we're to maintain fairness. So, whilst AI is increasingly used at administrative and now some civil legal tasks, justice systems should proactively establish ethical and professional standards, with oversight by judiciary, by legal professionals and technologists. And in England and Wales, whether through joint or multiple bodies, we must ensure that the do no harm principle is followed. As a member of our INS IT and AI committee, I will do all I can to ensure that Inner Temple is at the forefront of thinking on this most exhilarating, yes, yet bewildering of challenges. With a sense of humility and a willingness to engage in genuine collaboration, then AI can expand access to justice whilst upholding the rule of law. A true alignment that will retain that vital human element of justice. Thank you very much.
Sir Robert's kindly agreed to take some questions. Kerry, I can't, and those will include questions from those who I know are following this lecture remotely. Unfortunately, I'm no longer logged in, so I can't see any such questions. So I might need Kerry just to pop in. She's coming. Just to make sure that I can see them. But whilst Kerry's doing that, are there any questions? I'm sure there will be questions in the room.
If nobody else,
please do.
Can I thank you for absolute?
So they can hear you online as well.
Okay, I have what my family call a penetrating voice. Two questions. And I say it was a fascinating discussion. First of all, how confident are you that your excellent rules will actually be followed? And my second question is, as a former family judge, 5% of penalties are totally unreasonable in my 35 years of practice. I worry about child arrangements with that 5%.
Yeah. Well, to address your second point directly, Elizabeth, I absolutely agree. When I think about the need for human-led decision-making, I am thinking a lot about those difficult, the stubborn cases, particularly where there are irreconcilable parties, and you're dealing with life-changing decisions about the future of children in particular and family arrangements. They, for me, are as grave, as important as liberty of the individual in the Crown Court, where I spend most of my many years in practice. And therefore, what I've sought to do is not just set out some tiering of processes so that you've got the top tier of cases that need to be dealt with by human judges alone, but also the mechanisms within that whereby we provide the oversight that means that the use of AI doesn't tip over into some dystopian nightmare where we've lost control of the situation. At the end of it all, it's got to be alignment. The whole essence of justice itself has to command the confidence of those who use it. If we have a justice system that is no longer trusted or believed in by the public, we've got a problem. And we've seen elements of that where we've had miscarriages of justice that have resonated very strongly, the post office cases being amongst them. And therefore, whilst we've got a prize here in AO, it's a great prize. It can, I think, transform access to justice for millions of people in straightforward cases. Wonderful power that we can use. And it can free up court time to do the really serious, intractable stuff that you did and that I did and that many of us in the room have done. And to develop the law. But, if we let it run away with us, and if we don't actually set up the bodies that I think we need, and we do need scrutiny boards, we need that cross-disciplinary oversight here, then we are missing a trick. And here's the thing, it's already happening. The Digital Rules Committee that I'm proud of having to help set up, because I insisted that we put the clause in one of the bills that I was responsible for in order to get that going. We'd waited for that particular provision for quite a few years, and sage nods from members of the Lords. We did that, and now the Master of the Rolls chairs it, but it's got technicians on it as well. And there's the thing, we're already doing this, we're already bringing technologists together with our lawyers and judges to work together to make the system better. I think in AI, that's absolutely where we need to go. So that's how I believe that my principles or ones like it can be enforced. Thank you.
Because there are two questions online that are connected to the answer we've just given, I'm going to take those and then we'll come to more in the room. And I'm going to give you both. First of all, is it actually possible to remove or mitigate the biases in AI for a prospective AI justice system? And secondly, if there is going to be the rights to human review that you have identified as part of your framework, how do the regulators avoid AI adjudication just becoming a first hurdle, which everyone then just appeals from?
Absolutely right. I mean, I could do the second point first. It's absolutely the danger of the circular argument that, you've got the right to challenge, then that really becomes, the place, and suddenly we've lost all the advantages. I think that the two issues are linked. The more that we scrutinise the quality of the data, the more that we seek to be alert to and remove bias, then the more reliable the system will become, and the fewer the people that will be who will want to challenge it. So we can here create a virtuous circle if we get it right. If we just sit back and let the data take its role and carry on importing bias into it, of course we're going to get more appeals, and rightly so. But this is where I think that the challenge of bias is something that we have to rise to. I believe it is possible. It'll be quite painstaking to begin with, but already processes are emerging that will make it easier to, if you like, wash or cleanse or make sure that the data that we are using is absolutely replicating what we would use from our law sources, our books, our case law, all the things that we have traditionally got used to and absolutely rely upon. So the virtuous circle is what we want to create, because if we don't, we will end up in this system where AI will just be round one and it'll all be on the appeal. So it's a very good point.
This gentleman.
Just in relation to the first tier, as it were, of the most basic, or the fourth tier, sorry,
Yeah.
of the fully AI determined cases, what timeline do you think you're looking at for the rollout or introduction of a system of this nature? And just in relation to the first tier of the most complicated cases, why do you think those cases should not be AI assisted at all? Would judges not be assisted by using Westlaw AI tools in complement with Westlaw tools that we're using at the moment, for instance?
Yeah, I mean, I can say that there might be, I mean, I've tried to create a tier. It could be a 3-tier system. It could be a 4-tier system. What I'm trying to do is just, particularly the top end, really delineate between those cases where clearly some form of administrative assistance is absolutely fine. In fact, in a top-tier system, I don't see any problem in using some form of minor administrative assistance. I think the difference is that where, and this is something I've tried to develop, being very mindful of the fact technology is changing all the time, that we've got to be careful about not being too agentic. In other words, not just evolving quite major parts of very sensitive cases to what the AI can come up with. And that, particularly where the law is really vexed and really complex, we've got to be very careful about not just, pressing the button and seeing what happens. Agency is great, agentic forms of AI are great, but only if the law is pretty clear. And there's a very settled line of authorities. If you're in a case where you're having to really review a whole line of authorities back to first principles, then you've got to be very careful about the use of agency there. I think it does become much more of a human task, I think. And that's what I'm seeking to distinguish. At the bottom end, I think that the technology is already there. I think that government are going to try and avoid the pitfalls of building their own. They're already working with big tech, with OpenAI and with big tech platforms in order to develop the right sort of technology. My understanding is that this will not be a question of years and years, and that we are near to it. And indeed, particularly with administrative tasks, agentic AI could be used now. For example, in the enforcement of Crown Court orders by the issuance of automatic emails to all the parties 1 minute past the deadline at midnight on the 7th day, for example. It's all there, it's all available. And frankly, we should be getting on with it. So in my view, I think what we need to do is get on with what is safe now, and then go to, I think, an agentic system, which in effect is what I call single justice procedure plus. And I'm not going to give a timeline because, of course, I'm not in government. I'm not privy to these decisions. But I would think that when we're pretty close to a single justice procedure plus already.
Straight at the front here. Okay.
Thank you for a fantastic presentation. My question is two-pronged. I'll start with the first limb. Amongst social scientists, there's an eclectic range of definitions when it comes to biases, particularly pertaining to gender, race, and so forth. So for this ethics review board, how would you go about in ensuring that you have a range of definitions, legal practitioners who come to this ethics board with the qualitative or quantitative research that they do? And the second question that I have, it could be a bit tinfoiled, but please stay with me. What if, for example, the technologists who are also party to this, the algorithmic creations of these technologies, the ethics board in question say, this is how we define bias, and this is how we're seeing your technology perpetuating this. But then the technologists also have to satisfy certain nation states and certain administrations who may see such qualms of defining bias as X as being too DEI or being as too left-wing or too political focusing. And so the technologists have an issue where they have to work with this ethics board, but they may not get governmental contracts, or they may be scrutinized further if they take on these reviews. How would you square the two?
That's a really great question. I think that you've got to get the I word. You've got to have independence. It has to be. And, if it is judge-led and judge-involved, you've got the independence of our judiciary. I think the ethicists and technicians themselves, you need to declare their own interests as well, so that we know exactly whether they're, working for big tech or where potential conflicts might exist, so that we have, the sort of high ethical standards that you would expect anybody serving on a public body like that to enhance. Your point about bias is very well made. Of course, there are contested views about all of this. We know, the contested heritage issues with racial history, the whole range of different biases that exist across there. Disability is one that I'm particularly interested in from my own life experiences. I'm confident that even if you can't necessarily populate a board with the full range of views, that there should be access to a reservoir of experience and information that could be drawn upon. So you could have a panel of people with that expertise who could be drawn upon to have their input into it. So I think all this is doable. The very fact that we are talking about this is encouraging. It just shows that, we can avoid repeating the devolve and forget mistakes of past technology. So thank you very much.
I know there's some questions further back in the room, so gentleman with glasses.
Hello. Okay, thank you. So this might be a bit unfair. It's a question less on your presentation and I guess more on the ethos of the intellectual climate to which your presentation contributes. But one thing I've personally seen, and you mentioned this at the beginning, is that we see there's a lot of talk about how AI can be used in the judiciary, how we can use it for the justice system, and significantly less talk about how AI could be used either by the executive or by the legislature. So I'm just wondering, do you have any reason as to why that might be? Why are we seeing so much talk about one branch of the government and not the other two? Especially given that when I think about kind of which branch of the government really needs that human touch, to me, kind of the obvious answer is probably the judiciary.
Yeah. I love that question because I think about it a lot, having been in all three parts of our constitution at various times. In fact, at one time I was in all of them at the same time. I was a sort of throwback. I won't go into my view about checks and balances, which I firmly believe in, and I've lectured before about the fallacy of the separation of powers notion applying to the British Constitution. But your point, because we're not a separation of power, we are a checks and balances constitution. That's not an opinion, it's a fact. But coming back to the executive are, of course, looking at AI, but they're looking at it through the prism of efficiency. And inevitably, that does mean cutting the number of civil servants. Having presided over annual budgets, and huge budgets of the MOJ, the majority of the cost was on wages and on staff. And it has grown since COVID. So the pressure is on ministers now and senior civil servants to try and reduce headcount through the use of AI. And that's inevitably what they're thinking about. But this is where we, on our end, the justice end, can help inform the executive to say, great, but whoa, can you explain your decisions? Are they accountable? Do you understand what the black box is doing? Because if you don't understand, who's in charge? All these questions have got to be thrown back to the executive. Now, the legislature, I think this is fascinating, because if we think that court systems aren't immune to changes from AI, then, we've got a member of the House of Lords. I was a member of the House of Commons for years. I can tell you the processes that we use, which have been refined, basically from the 18th, 19th century, look rather, should we say, archaic, perhaps even, in the eyes of the AI development. And here's the thing, with the increasing pace of human activity, the legislative process can feel exceeding slow at times, even though the quality of scrutiny is something which I defer to Master Butler Sloss's house, which is extremely important and very, very valued. But Parliament is going to have to think about how more effectively it is going to incorporate AI. I say this, already I'm seeing, because I still take a huge interest in legislation, amendments that are being tabled that clearly have had their genesis in perhaps a co-pilot or, dare I say, a chat GPT. We're going to probably see more amendments coming forward because legislators have suddenly got these virtual assistants who can help draft things before they go into the bill office with our wonderful draftsmen and women who then look at it all and actually make it work. So yes, I think that Parliament's going to have to wake up to the power of AI as well.
To what extent can we leverage other countries in relation to this, whether it's Parliament or the judicial system? I mean, what you've described, if I may say so, sounds quite expensive at the upfront,
Yes.
even though it will save
Yes.
money in the long term. So is there a global solution of some kind? Or
Well, I'd like to think
international
so.
solution?
I'd like to think so, but I think at the moment with the international institutions frankly being sclerotic, let's be honest, I'm not confident that we can get that level of international agreement. The UN peacekeeping capacity is negligible. The World Trade Organization is in trouble. We are not living in an age where there seems to be the sort of what I call the spirit of San Francisco, the 1945 will to build an international framework to not rely upon the rule of strong men. It's as if the lessons of 80 years ago are all being unlearned at precisely the wrong time when we've got this incredible avalanche of change that AI is bringing. This is a time when we need that sort of structure and leadership that I'm afraid I don't think is being remotely provided for. But here's the thing. I think that we in the past as British lawyers, English and Welsh lawyers, Scots lawyers, Northern Irish lawyers, have led the way in many respects on many, many good things that have been used and are being used across the world. What a wonderful thought to have that now in this century we might be able to help lead the way on the safe use of these technologies in justice systems. And also there's frankly commercial consideration as well. The idea that this jurisdiction can just sit back and carry on with its metaphorical quill pen while other jurisdictions might be racing ahead and using this technology will ultimately undermine the reputation of this jurisdiction as a place for dispute resolution, and we will lose out in terms of legal services. So there is if you like, an enlightened self-interest here as well, which I think should be harnessed. It's morally good to lead, but also, let's face it, good business as well, and good for legal services in this country. So I don't think we can leave it to others, and we certainly can't leave it to international institutions, I'm afraid.
Well, I think on that note of hope and enthusiasm, we'll bring this evening's events to an end. I'm sure there were other questions, but we can take some outside for those who are present in the room. So it just falls to me on behalf of all of those present, those who've been watching this online, to thank Sir Robert very, very much for a really fascinating indication of both the possibilities, certainly the challenges, but also the hope that with a proper framework, we won't be sitting here in 5 years' time looking backwards, thinking, oh my goodness, we missed that opportunity. We're really grateful to you for coming and sharing your insight with us this evening. Thank you.
Thank you. Thank you. Thank you. Very much. Thank you.
Do you come and have a drink?